Start. Heard Shri O.P. Singh, Senior Advocate assisted by Shri S.K. Rao, Learned Counsel for the Appellant and Learned Standing Counsel for the Respondents full stop para. This is an appeal against the order of the Learned Single Judge dated 20.7.2010 passed in writ petition number 70001 of 2009, whereby the writ petition filed by the appellant has been dismissed full stop para. The appellant was a constable in police department full stop. Admittedly, he had been convicted by the trial court for the murder committed by him and punishment of life imprisonment has been awarded full stop by order dated 7.9.2002, the appellant had been dismissed from service under Rule 8 in bracket 2 in bracket A of the UP police officers of the subordinate ranks in bracket punishment and appeal bracket out. Rules 1991 in bracket hereinafter referred to Rules 1991 bracket out. Being aggrieved, the appellant filed writ petition which has been dismissed full stop. The learned single judge held that the issue involved is squarely covered by the judgment of this court in the case of Brahmadev versus Life Insurance Corporation of India, 2006 in bracket 3 ALJ 710, which is based on the decision of the apex court in the case of Deputy Director of Collegiate Education in bracket administration bracket out, Madras versus S. Nagur Meera AIR 1995 SC 1364 full stop para. Learned counsel for the appellant submitted that against the order of the trial court convicting the appellant, an appeal has been filed wherein the sentence has been stayed and therefore the dismissal order is liable to be set aside and the appellant is entitled to be reinstated in service full stop para. We do not find substance in the argument of learned counsel for the appellant full stop. Rule 8 in bracket 2 of the rules, 1991 reads as follows, colon, Rule 8 dismissal and removal, colon, first, no police officer shall be dismissed or removed from service by an authority subordinate to the appointing authority full stop. Second, no police officer shall be dismissed, removed or reduced in rank except after inquiry and disciplinary proceeding as contemplated by these rules full stop, provided that this rule shall not apply. A. Where a person is dismissed or removed or reduced in rank on the ground of conduct which has led to his conviction on a criminal charge, colon, or a bare perusal of proviso of Rule 8 makes it clear that the police personnel can be dismissed or removed on the ground of conduct which has led to his conviction on criminal charges even without any disciplinary proceeding being contemplated. Therefore, exercise of power dismissing the appellant on the ground of conduct which has led to his conviction on criminal charges cannot be said to be illegal full stop. Para. In the case of Brahmadev versus Life Insurance Corporation of India in bracket supra bracket out, not only the sentence but even the order of conviction was stayed in appeal and effect thereof was considered full stop. It would be useful to reproduce paragraphs 11 to 16 of the said judgment as under colon para. Now coming to question number 1, in my view the power under regulation 39 in bracket 4 bracket out can be exercised even if the order of conviction and sentence passed by the criminal court is stayed in appeal, full stop. A perusal of regulation 39 in bracket 4 bracket out shows that the factum of conviction on a criminal charge is sufficient to empower the disciplinary authority to consider the circumstances of the case and pass such orders as it may deem fit, full stop. Whether the order of conviction is operating or not, or whether it is executable or not, is of not much relevance for exercise of power under regulation 39 in bracket 4 bracket out of the regulations of 1956, full stop, para. A similar question came up for consideration before the apex court in the case of Deputy Director of Collegiate Education in bracket administration bracket out Madras versus S. Nagur Mira AIR 1995 SC 1364, full stop. The apex court considered the peri materia provisions contained in Article 311 in bracket 2, second proviso clause in bracket A of the Constitution of India and said that what is relevant for exercise of power thereunder is the conduct which has led to conviction in criminal charge and not the conviction itself, full stop. There is no question of suspending the conduct of an employee when he has been convicted, and in any appeal the same is stayed, full stop. Since the disciplinary authority has to exercise power considering the conduct of the employee, comma, which has led to his conviction on a criminal charge, and since conduct is not stayed, therefore, comma, even if the conviction has been stayed in appeal, the power can be exercised by the disciplinary authority on the basis of the conduct which has led to conviction on criminal charge, full stop, para. The relevant observations of the apex court as contained in para 8 are reproduced as under colon. We need not, however, concern ourselves any more with the power of the appellate court under the Code of Criminal Procedure, for the reason that what is relevant for clause in bracket A of the second proviso to Article 311 in bracket 2 bracket out is the conduct which has led to his conviction on a criminal charge, and there can be no question of suspending the conduct, full stop. We are, therefore, of the opinion that taking proceedings for and passing orders of dismissal, removal or reduction in rank of a government servant who has been convicted by a criminal court is not barred merely because the sentence or order is suspended by the appellate court or on the ground that the said government servant accused has been released on bail pending the appeal, full stop, para. It has also been held by the apex court in the same judgment that in cases where an employee is convicted on a criminal charge, the appropriate course would be in all such cases to take action and not to wait for the result of the appeal or revision as the case may be, full stop. It is always open to the authorities to revise its order and reinstate the government servant with all the benefits if in appeal or other proceedings the government servant accused is acquitted, full stop, para. Similar view has been taken by a division bench of this court in the case of Mohan Lal versus State of UP 1998 in bracket 78 bracket out FLR 987 colon in bracket 1998 all LJ 987 bracket out, full stop, over.